Imagine this. You see a terrible accident. It's really upsetting and it sticks with you, causing you serious emotional distress. This isn't just being a little shaken. This is nervous shock. It's a real psychological injury and the law recognizes it. Nervous shock, which doctors sometimes call psychiatric injury, comes from a very upsetting event. It's more than just feeling sad or grieving. It's a real mental illness like PTSD, anxiety or depression. The law understands that trauma can deeply affect your mental health. Nervous shock claims recognize that you can be hurt in ways that aren't physical. This is important for getting justice for people who experience psychological trauma. Not every upsetting experience counts as nervous shock in court. The law is very specific about what qualifies as nervous shock, and it's not enough to simply feel distressed or upset. The courts require a more substantial impact on your mental health. To get compensation, you have to show a few specific things. These elements are crucial in establishing your case and proving that you deserve compensation for the mental harm you've suffered. First, the person you're claiming against, the defendant, had a responsibility to keep you safe. This is known as a duty of care, and it means that the defendant was expected to act in a way that would prevent harm to others. This responsibility happens when it's reasonable to think that carelessness could cause harm. The law looks at whether a reasonable person in the defendant's position would have foreseen the risk of harm. For example, drivers have a responsibility to keep other people on the road safe. This means they must follow traffic laws and drive carefully to avoid accidents that could injure others. Second, you have to prove that the defendant didn't meet that responsibility. This is called a breach of duty, and it means showing that the defendant failed to act as a reasonable person would have in the same situation. This means they acted carelessly, and that carelessness led to the upsetting event. You need to provide evidence that directly links the defendant's actions to the harm you experienced. Finally, you have to show a direct link between the defendant's carelessness and your mental injury. This is known as causation, and it requires demonstrating that your mental injury was a foreseeable result of the defendant's actions. This often means showing that the harm was foreseeable, meaning it was something a reasonable person could have predicted. If you can establish all these elements, you have a strong case for compensation for nervous shock. The law sees two types of victims in nervous shock cases, primary and secondary. Understanding this distinction is crucial for anyone involved in such cases. This difference helps decide how close you had to be to the event to make a claim. It essentially determines the proximity required to be considered a valid claimant. Primary victims are directly involved in the upsetting event. They are the ones who experience the traumatic incident firsthand. They are in danger themselves and fear for their own safety. This immediate threat to their well-being is what classifies them as primary victims. Imagine a driver in a car accident caused by someone else's carelessness. The driver, who is directly impacted by the crash, would be considered a primary victim. They would be a primary victim. Their involvement in the incident is direct and personal. Secondary victims see the event or its immediate aftermath. They are not directly involved but are witnesses to the traumatic event. They aren't in physical danger, but they're deeply upset because of their relationship with someone who was. Their emotional distress stems from their connection to the primary victim. Think of a parent watching their child get hit by a car. The parent, although not physically harmed, experiences severe emotional trauma. They would be a secondary victim. Their distress is real and significant, but proving it in court can be more challenging. This difference is important because it's harder for secondary victims to prove nervous shock. The legal system requires more evidence to establish their claim. This is because their connection to the event is less direct. Understanding these distinctions can help in navigating the complexities of nervous shock claims. Some big court cases have shaped how we understand nervous shock claims. These landmark cases have set precedents that influence how courts handle such claims today. These cases show how this complicated area of law is always changing. The legal principles surrounding nervous shock are continually evolving as new cases are brought before the courts. One case is Borehill v. Young, 1943. This case is often cited in discussions about the limits of liability for nervous shock. A pregnant woman, Mrs. Borehill, heard a motorcycle accident and later saw blood. The traumatic experience led to her suffering a miscarriage. She had a miscarriage and sued the motorcyclist. Mrs. Borehill claimed that the shock from the accident caused her to lose her baby. But the court said no, because Mrs. Borehill wasn't close enough to the accident to be considered a foreseeable victim. The court ruled that the motorcyclist could not have reasonably foreseen that his actions would cause harm to Mrs. Borehill. Another important case is McLaughlin v. O'Brien, 1983. This case expanded the scope of who could claim for nervous shock. Mrs. McLaughlin was traumatized after seeing the immediate aftermath of a car accident involving her family. She suffered severe emotional distress from witnessing the condition of her loved ones. Even though she wasn't at the scene, the court agreed with her claim, making it easier for secondary victims to claim nervous shock. This ruling acknowledged that the impact of witnessing the aftermath of an accident can be just as traumatic as being present at the scene. These cases show how courts are trying to protect people from mental harm while also making sure the system isn't overwhelmed with claims. The balance between providing justice for victims and preventing an overload of claims is a delicate one, and courts continue to navigate this complex area of law.